by Bharat Chamber of Commerce this morning. I would like to invite our guest speakers this morning. May I start with our guest in chief, Dr. Onkar Sharma, Welfare Commissioner, Central Ministry of Labour and Employment, Government of India, to please join us on the dais. May I request Srimati Monisha Sarkar Bhattacharya, Director, State Labour Institute, Government of West Bengal, who would be introducing the theme and talking about West Bengal perspectives to the dais. Let me now invite industry perspectives. Mr. Rajiv Srivastava would be sharing the industry perspectives. He's the Deputy General Manager, Tata Motors, Jamshedpur. I would now invite Shri N.G. Khaitan, President of the Chamber, to join us on the dais. Mr. Naresh Pachisia, Senior Vice President of the Chamber, to join us on the dais. Mr. Rajkumar Agrawal, if he's here, if he could please join us on the dais. We would be starting this session with the welcome address by Mr. N.G. Khaitan, President, and I request the President to deliver the welcome address.
Dr. Sharma, first of all, good morning to you all. We are having this discussion on labor reforms after a long time on the subject of the labor. And we are very happy today that we have Dr. Sharma, Srimati Bhattacharya, Sri Srivastava amongst us. We have various participants, HRs of different companies. In fact, one of my friend, Mr. Dasgupta, just told me that from his company, he has asked 3 HRs of different divisions to join. So that shows the interest of the people on this particular subject of labor reforms. Sir, when I joined my profession in 1970, the most profitable area of my practice was, although I was a junior, but the most profitable area of my firm practice was labor unrest. There used to be, it was known as an era of Gherao. I mean, every day there was a Gherao in 1 or 2 industrial houses or people, and we used to go to the High Court and take precautions. And then there was an era of lockout, there was an era of strike, there was an era of suspension of work. I mean, most of the time, you know, every day I think we would issue a notice on suspension of work, we would issue a notice on Gherao, we issue a notice on lockout. There would be setting up of the disciplinary committee. And maybe we were making money out of it, but there was no pleasure out of it. I mean, honestly speaking, we felt very sorry if somebody was being Gherao. We felt very sorry that we are issuing a lockout notice, which will take away the employment of so many people. They will not go earn wages. So it was not a very comfortable practice. But I am happy to report that in last few years, I mean, I'm very honest, in last, at least for 15-20 years, there is hardly any lockout notices we issue. I don't see any case of Gherao anymore. There is hardly any suspension of, so therefore there is a total transformation has taken place as far as, I mean, sir, you will also agree, he comes from Tata Motors. I mean, we don't see that. So it's a new era. I mean, if I say very honestly, it's a new era on labor reforms. We say that, you know, the 4 codes have come. I mean, the question is, when will it see the light of the day? I mean, that's again an issue. I mean, it's all right that you have merged 29 acts and into 4 codes, and when it will see the light of the day. I mean, I have to introduce the speakers here, but let me tell you, if I have to introduce Dr. Sharma, he has a very strong sense of eyes, we both traveled yesterday from Delhi to Calcutta, and he was introduced to me and he asked me, did you travel with me to Calcutta yesterday? And I said, yes, but I didn't recognize him. And so you can understand what strong eyes he has and what strong memory he has. So Dr. Sharma has been, people say he requires no introduction. And of course, he requires no introduction because he is a well-known figure in India. He came all the way from Delhi. He has been responsible for framing and execution of welfare policies for unorganized labor. He was one of the masterminds behind the formulation of new labor code, which we are talking about, and therefore a most appropriate person to enlighten us on this particular issue. Dr. Sharma serves as a member of National Human Rights Commission and the Standard Review Mechanism of ILO. Dr. Sharma would be deliberating for us and would be educating us on the decoding of the labor code, sir. So thank you very much, sir, for coming all the way from Delhi and addressing because West Bengal is very important because this was a very volatile state as far as the labor law was concerned. But then we take a pride that, our chief minister take a pride that no labor strike, no lockout at least since they have come to the power. Then we have from the state government, Srimati Manisha Sarkar Bhattacharya, Director, State Labour Institute, Government of West Bengal. Srimati Bhattacharya is at the helm of imparting training to the prospective labor welfare officers of our state. And you will agree that I've been speaking good about the state as far as the labor issues are concerned. So I do hope that you will give this state perspective on the labor issues. Then we have Mr. Srivastav. He's from Tata Motors, Jamshedpur. So we would expect to understand his perspective, on how he feels about the new labor law, new labor code, what has been his experience with the labor within his industry. It's one of the largest industry in the Eastern India. Tata's, as you know, they had one of the largest group running Tata Motors, Telco, Tata Steel, and so many units in West Bengal. So they will give a right perspective as far as what does he feel of the current scenario, what further reforms are needed. I think this is one area where a lot of debate takes place, that is this labor code enough or do we need more further reforms? I thought that you will be the right person, sir, to guide us because you have gone through all the nitty-gritty of the labor code. Dr. Sharma would tell us, of course, about the labor code and the perspective, but are there any further reforms are required? I mean, ease of doing business. We are talking of ease of doing business. And apart from ease of doing business, I think the most important is ease of living also, sir. I mean, these are two aspects from the labor law. And the ease of living, not only from the point of employer, the ease of living also from the point of employees. I mean, this is one area where, because when we talk about the industry, we only talk about from the ease of living as far as the employer is concerned, ease of doing business as far as the employers are concerned. But ease of living is very, very important as far as the labor are concerned. We are very concerned that, the laborers their employment is secured, they have a proper working condition for employment. But at the same time, if there is a misconduct or anything like that, then strong disciplinary action need to be taken. I don't know. There has been a debate on whether India should have a policy of hire and fire. I mean, this is a very debatable issue because they say that because of this particular policy of hire and fire, that we have 90% of our labor force is in unorganized sector. because people do not want to have permanent laborers. They want to have contract laborers. This is one area, I mean, which we have to think about, but we have to take into consideration the perspective of the welfare of the laborers also, whether we are in a situation, because we are in a situation where there is a acute unemployment. And I can understand, if there is no unemployment. But let me tell you, there are many states. I am a director of many companies, let me tell you that. And there are many states where we don't get workers anymore. Many states, the workers are not available. There is a total attrition, skilled workers, particularly, they are not available. There are states where you have a lot of unemployment, but there are states I know where the workers are not available. I mean, you don't get workers to work for you. This is again a very, very important issue that how do you tackle that situation? I mean, that I think you would agree, sir, that this is being faced by many states, particularly the industrialized state where the workers are not available. There is an attrition and you don't get workers to work for you, particularly Rajasthan, particularly Andhra, Telangana. I know these states because I'm directors of some companies who have large factories there, and they tell me this, that we don't get enough workers. In fact, sometimes there is a slowdown. So therefore, this is a very critical area. I mean, very critical that how do we do, whether these labor reforms, whether this labor code, we have this Shram portal which has been announced. So many new schemes like, have this Shram portal, Atmanirbhar Bharat Rozgar Yojana. Then you have this Pradhan Mantri Shram Yog Mandhan Yojana. I mean, these are so many initiatives which the government has taken. The labor code, out of 29 acts, we have this code on wages, industrial relation code, occupation, safety, health and working condition code, and the code on social security. So all these areas have been taken into consideration. Then the issue comes as far as the wages are concerned. What would be the meaning of the wage under the new code? How a wage is to be taken into consideration as far as the calculations are concerned, which is a little gray area. So I on the whole, I feel that this topic is a very relevant topic, both for employer and both for employees. And with these words, I thought I didn't want to take too much of a long time. I mean, I'm no expert of labor law. I never practiced labor law, but only I practiced those bad side of the labor law, never the good side of the labor law during my junior days. With these words, may I now request, our speaker, Srimati Manisha Ji Sarkar, I mean, the representative from the government of West Bengal, to speak and give her perspective of the labor. And if you don't mind, sir, we would like to sit there because you will be doing some screenshot, or we're just speaking. So we would go and sit there and hear you.
No mouse.
Hmm? Hmm. Thank you. And first of all, I would like to greet all of you, especially the organizers, for providing me the opportunity to be present here. Not as a speaker, but as a listener. Because I want to hear from Mr. Sharma in this regard. It's much awaiting things. And I will also like to greet all the dignitaries present here, all my colleagues, my co-workers, and obviously co-performer. Because this is the act, this is the area of laws where all of us basically performers. We do have separate functions, and ultimately that provides a result which is acceptable, which is accepted by societies. And discussion is the best way, and this sort of experience sharing is the best way for learning. So this sort of seminars as organized by Bharat Chamber of Commerce today will be helpful for all of us, I hope. Now this labor law reform, as we all are waiting for the version of Dr. Sharma, we will be just, at least I will be just trying to introduce the theme in a very short way. Now, if we think about reform, what is reform? We are talking about reforms, not revolution. Here, the term is reforms. Reform means to make changes in something in order to improve it. So, before reform, before we are trying to reform anything, first, we should be sure about that it will be better for all of us who are the part of this field. The common synonyms are amend, correct, rectify, redress, remedy, revise. All these words mean to make right what is wrong. For the laws, the term amendment is always there. Since inception, the laws are amended for, say, 50 times one law. But it is not reform. Reform is something else when improvement or set of improvement made in a system in order to make it more modern or effective. So not only betterment, here the effectivity and the need of the hour is also incorporated in it. It is basically antithetical to revolution. In case of revolution, we just want to change something and to delete something which was old ideas. But in case of reform, we do not delete it. We just make it more effective for day-to-day use. And then what is and are labor laws? We are using the term labor law, and labor law. But what is labor law? There is no law, namely labor law. One is there, but that is for different thing. That is for common return and others. For that act, Labor Law Act was introduced, but actually there is no law, namely labor law. Initially, it was called also industrial law. Now labor law is a more wide concept because not only industries, other are also incorporated in it. And we will see through this reform how this is incorporated, how it is changed from industrial law to labor laws. These are number of laws related to labor which are categorized as labor law. Labor laws are those that mediate the relationship which was known as, is also known as industrial relation between workers, employing entities, trade unions, and government, obviously. Labor legislations are divided into actually 4 categories. I have wrongly written the 3 categories: protective regulation, regulative legislations, social security legislation, and welfare legislation. And we will see when the code will be introduced later, then we will see that these categories are actually there, but the name is somewhat different. Now, what is industrial relation? Because industrial relation is the root cause of these changes. Industrial relation is a concept, is a developing dynamic concept, and does not limit itself merely on complex of relations between unions and management. Basically, apparently industrial relations means the industry and the workers, the employer and the workers. But it's not only employees, not only workers. It's a set of interdependent complexities involving various factors or variables, such as economic, political, social, psychological, legal. These are the factors or variables which changes it in different way. And when we, the viewers, not as a part of it, we, the viewers, when look it from the outside, this sphere rotates. As the viewer changes, as the intensity changes, any of the changes in any of the factors of this part, if changes, then its dimension also changes. That's a dynamic system. Whenever we are thinking about worker, we look, see, this should have been better, but when we change, see it from the part of the employer, it also changes a bit. First, where from this concept came of labor laws. Initially, when the primitive days, we do not have any laws, but still the industry were running. But industry, not only actually industry, but service sector was running. But this labor welfare activities arose in colonial India in reply to the need of cheap labor. After the First World War or so, this changes the requirement of cheap labor, as the India was a labor-intensive country for long. So Apprentice Act of 1850 was passed. Fatal Accidents Act of 1853 aimed at providing compensation to the families of died or disabled worker. Then Factories Act of 1881, or it's 83, which was the first Factories Act, which was later amended. Actually, that was deleted and new act was introduced later. Then when the International Labour Organization came into the picture, they recognized the importance of labor in the economic and social reconstruction and suggested some changes in the labor welfare scheme operating in India. As a result of that, different laws came up to our independence days. Then comes the Indian Constitution. Indian Constitution, it has directive principles and state policies and also fundamental rights, some of which are directly related with labor laws, but not actually directly related with the root of these labor laws which came thereafter in our country as different labor laws. Article 14 commands states to treat any person equally before the law. Those who are related with labor laws, they can easily recognize which act it is intending at. Then Article 19 grants citizens right to form association of union. 21 promises protection of life and personal disability. 23 prohibits forced labor. 24 prohibits employment of children below the age of 14 years. These are the fundamental rights which later converted into different labor laws. Article 39 provides that state shall secure its citizen equal right to an adequate means of livelihood. 39A provides for state shall secure the equal opportunities to access to justice to its citizens and ensure that such opportunities are not denied by reason of economic or other disabilities. 41 provides that within the limit of economic capacity, the state shall secure for the right to work and education. Article 42 instruct states to make provision for securing just and human condition of work and for maternity relief. Article 43 orders the state to secure living wages, decent condition of work, and cultural opportunities to all workers through legislation or economic organization. And finally, Article 43 provides for participation workers in management of industries through legislation. These were the background, and then labor laws coming and coming and coming. Labor falls under the concurrent list. So both parliament and state legislation can make laws regulating labor affairs, basically. It is assessed that there are over 100 state and 40 central laws regulating various aspects of labor, such as resolution of industrial dispute, working conditions, social security, and wages. First, Committee on Labor. Now, after introduction of these acts, it come into force and it works. And then as per requirement of society and industry, this act changes in different time. And for these changes, first, the Committee on Labor Welfare 1969 noted that labor welfare includes such services as facilities and amenities as adequate canteen, rest, recreational facilities, sanitary and medical facilities, arrangement for travel to and from work, and for the accommodation of those workers employed at a distance from their homes, and such other services and amenities as contribute to improve the condition and under which a worker will participate, employed. According to this and thereafter, there are amendments of different acts, and the states also makes their, in their rules or by notification in the main act, they sometimes changes the different aspects of law. Especially one area is the number of workers for which is required in an establishment for one act to be enacted. That was been changed in different states in different way as per requirement. Especially in West Bengal, we have changed the Contract Labor Regulation and Abolition Act in such a way that it is applicable for industries where 10 contract labor are working, which is 20 in the Central Act. So this sort of amendment has been made in different acts to make it applicable in their state only. And Central Acts also has been changed in Bonus Act, in Gratuity Act. We said several times the number of workers, the amount of maximum gratuity, this has been changed. And for other aspects like definition of workman and like applicability of Gratuity Act, that's also been changed for different states. Now, this second National Commission on Labor recommended consolidation of central labor laws. It observed that there are numerous labor laws, both at the center and the state. Further, labor laws have been added in a piecemeal manner, which has resulted in the laws being ad hoc, complicated, mutually inconsistent, and varying definition and containing outdated clause. Basically, the last two are the most important because different definitions in different act make employer, employee as well as the law implementer in the same way. Because in different act, it defines, worker is defined differently, wage is defined differently, establishment has been defined differently. So whenever we are going to an establishment, we the implementer was to an employment there, and we just make an inspection. We find it very tough that which act should be applicable there, for which that will be a notice is to be given for them. It will be confusing for all of us. Therefore, this labor reforms finally, which is at present on the floating surface, is basically the labor reforms in form of labor codes, which actually consolidated different labor laws. 29 labor laws have been consolidated. Other 11 has not been included in this, because those have different aspects like Child Labor Act, Bonded Labor Act, that is Child Labor Abolition and Regulation Act, and Bonded Labor Prohibition of Condition of Service Act, that has not been incorporated in this code. However, what is taken in care of, simplification of labor laws, the basic idea, because different labor laws have different applicability, different sort of applicability, different sort of people is depending upon this. And thereafter, another thing is that in different laws, there are so many registers, so many forms, so many returns, and it was better to have the same sort of acts to come under one umbrella and one sort of register and other issues that will be easier for the employer as well as the act implementer. So first issue is simplification of these labor laws. Then facilitating job creation while protecting work. It's an interesting thing. If we look it from one part, that is job creation and protection of work. When suppose a contract labor is working in a industry, his work is not protected. He is not protected under laws because his employer is someone else, that is the contractor. If any accident and others occurs within the establishment, and if that worker is not covered under ESI through his employer, he will not get the facility, all the facilities. So these sort of things, protection will be given. On the other hand, contract, it is to be changed in any other form that we will discuss later, but that will be introduced by Sir. Okay, these are the things, the different names have been given to them. The contract, it's a short-term work contract, but that will be more safe because in case of contract labor, he was introduced through a third party, and that third party can change any day, any worker. It is a manpower contract. Like, you will give me 3 workers for this job for throughout the year, and that 3 people can be changed anytime. So here, protection of work means protection in both the protection of job as well as protection in the area of work, in this workplace. Coverage of establishment under labor laws. In different labor laws, the coverage umbrella is different, where somewhere it's 10, somewhere it is 20. In Factories Act, there are 2 categories, without power and with power, and the number of workers will be different in that case. Now, some sort of ideas are also there. If those things, if those units, they just avoid to increase the number more than 10, because in that case, they will be under so many labor law purviews. So what they think, let me keep it 9. If he needs a more worker, he will be taking it through contractor. He is not taking it into his direct payroll, because in that case, he has to face the music of so many labor laws. So this coverage of, it's one part that if we increase the number, so in that case, more number of units are coming out of the purview of the act. But In another sense, it will give, say, or 10, up to 10 workers, otherwise all the facilities of the Act. Because if he is in an industry, if he is in directly in payroll of that unit, if he is not a contract labor, it will be better for him. And in the other way, the management also will not think twice. But there should be a cap, like the things which are basically required for his survival, like ESI Act. Coverage should be. Even there is one number of worker only. Because that is the thing which is required for his survival. So this sort of capping, if it can be done, that it's the best thing. If we want to reform it, we can think of these things also. That we, it actually 33% are in service sector. And out of this 33%, only 7% are coming under the purview of the Act at present, when it's 10 is the general category. So if it increased to 20, it will not that the say 7 will be decreased to 4 or 3, because the worker will be taken, more workers will be taken in that field and the number will increase, hopefully. Thresholds of layoff, closure and retrenchment that are there, because again, the things that if 100 workers are there, they need to take permissions, so on and so on. And for this, all these things that can be increased, that number can be increased, and it is proposed in the labor codes. But again, there should be another sort of another sort of protection layer they should get in against this changes. Labor administration, obviously, we do have, it will be helpful for us at least. Then delegated legislation, it is also that different states needs different sort of changes in the Act, because as the sir was previously talking, somewhere unemployment is a factor and somewhere need of worker is a factor. So this sort of delegated legislation will facilitate the process so that worker can migrate in other states if all the other issues can be taken care of. And the states will be given permission for that to make any sort of this change in the Central Act. Then emerging challenges. That is the thing we are hearing each and every day, like ease of doing business. Now, this ease of doing business, in our old acts, some clauses are there which actually not allowing this. For ease of doing business, we need to do certain changes in different acts, and that can be facilitated through this reform. New concept of gig worker, platform worker, all this came, and this can be useful for this sort of challenges that we are facing today, the global India, or say global world. We can changes, we can face the challenges by changing our laws in that way, and introduction of new ideas, which was not possible actually. When the laws were actually enacted, we had so many things that is beyond imagination on that day, and we are facing today. We are doing all these things. So for this emerging challenges, this new act can be, new codes can be helpful. Now, this is just a part, that is the Payment of Wages Act, which code on wages, Industrial Relations Code, Occupation, Health and Safety, and Social Security Code. In these 4 codes, we have taken in 29 labor laws in 4 separate units, which can be helpful for us. Now, this one thing, that is labor law reforms. This is ऐसे तो कानून अंधा होता है, लेकिन labor laws are not blind. Here, labor laws are definitely, it has definitely a vision, that is the betterment of worker, not at the cost of employer, but they can grow together. So these labor laws always aimed at changes, rather reforms, which can be beneficial for industry actually, not employer, not worker, not us, the implementer. It is actually betterment for all. So it always provides us a win-win situation. Here, no one will be the loser. So it is known as reforms. Here, we are using the term reform because it will help us to reach in a situation which is good for our industries, we people, as well as our society. So that's all. Thank you for hearing me. And again, I will be waiting to listen from others. Thank you once again.
Thank you, Madam, for that comprehensive presentation in a nutshell on the labor laws and the background of the labor reforms. And we look forward to listen from Dr. Sharma in greater detail. Meanwhile, I would invite Mr. Rajiv Srivastava from Tata Motors to make his presentation on the industry perspectives on labor reforms.
Yeah, good morning, everyone. First of all, I thank you, Bharat Chamber of Commerce, for inviting me and giving me this privilege to just speak before you regarding the industrial perspective of new labor codes. Respected Dr. Sharma sir, Sri Khaitan sir, Mrs. Manisha Sankar Bhattacharya ji, our HR fraternity friends, and representative of different industries. First of all, why this we are discussing this labor reforms, why it is required? As ma'am has said, with time, some changes are required. But for running industries, I just want to put forth 10 mantras. If we follow these 10 mantras, labor reforms or labor laws will not be required. These 10 mantras are being on time. These 10 mantras doesn't need any talent. And we will run our business or industry very harmoniously. Laws only give you guidelines, what we have to do and how we have to do. And we have to run our all sort of issues or all sort of business practices within that line. So this is being on time. This doesn't need any talent. Works ethics. Most of the disputes come out of this only, either from employee side or employer side. If we do not follow ethical practices, then there will be some issues, and to resolve those issues, we need laws, or we have to go to see the provisions in different laws where it is applicable or how it. Then it is effort. Every business needs either effort from workman side, either or from employer side to run it. And if from any side there is lacking, there will be some issues. Energy. When we are coming for our duty, we should give our 100%. It is not be a time pass. Then it is body language. This also very important. Whenever and wherever you are, you must show a positive attitude. Then passion for your work. Definitely, this gives a different perspective of your day-to-day professional life. We must have a passion for whatever role we have been assigned by the organization, or whatever capacity we are working, whether I may be employer, I may be a manager, or I may be a worker. Then doing extra. It is not that ki 8 to 5 mera kaam ho gaya or that's all. This only is expected. Always try to give something extra. अगर मैंने आज मुझे कुछ देना है तो just ये नहीं कि my job is over and that's all, thank you. Try to give something extra wherever and at what capacity, which capacity you are working, irrelevant. थोड़ा सा ज्यादा दो, just देखिए कि what result you will get. Being prepared. जो भी काम करना है उसकी प्रिपरेशन हमें करनी है पहले, तब मैं आउटपुट दे पाऊंगा. अदरवाइज इट विल बी डन विथ हाफ हार्टेडली, और ऊपर इसके पहले whatever I have said, it is not achieved. Then being coachable. Coachable means you must ready to learn. ये नहीं कि मुझे सब कुछ आता है और I am the expert in my field. Whether I am a worker or manager, whatever I know is the best or is the only way of working. This is not the right way of doing what I feel, or what we are practicing in our industries. We should be always ready to learn. And then attitude, which is the most important thing. Our attitude should be positive to get work done from our employees or get best out of them. If our attitude is not right, it is very difficult to get 100% out of them. So I think if these 10 mantras we will follow, there will not be any issue in any industries. Then let's come to the main topic, labor reforms. As we know, this India government has implemented or recommended by the Commission for Amalgamation of 29 laws in 4 different labor codes. Those codes are Wages Code, This is basically amalgamation of 4 labor laws. Industrial Relation Code. This is amalgamation of 3 labor laws. Social Security Code. This is basically amalgamation of 9 labor laws. And occupational safety, health and working conditions. This is amalgamation of 13 labor laws. And what is going to change by this? The most important thing, this is the recognition of trade union. Then types of employment will also change. Then dispute settlement mechanism will change. Provisions of strikes and lockout will change. Then layoff and retrenchment and closures, there are some conditions. This will change. Compensation and welfare measures, this will also change because there are provisions for some floor wages, which is over and above this minimum wages. Then engagement of contract labor, madam has already said. And there is a provision for gig and platform worker, recognition of these workers. Although these sort of workers are prevailing in our societies since long, but this is the first time when the government has thought to give recognition and social security to these type of workers. So let us go one by one. What this trade union, recognition of trade union under IR code will change. In IR code, recognition, earlier there was only registration of trade union was mentioned, and the way for recognition, it was not well defined. It has some states may have provisions for recognition of their union, but at central level it is not defined. In this reform, in negotiating union, concept of negotiating union and negotiating council has come up, and it is well defined when and under which conditions the union will be when employer are going to constitute a negotiating council, or when a union will be a sole negotiating agent, under what conditions. So this is an important change which we see from industrial perspective. Then the type of employment, standing order applicability has gone from 100 to 300, and this has given an opportunity to the industrialist or to the industry to just made applicable standing orders only after when they will employ more than 300 workers. And this will also give a new perspective to the employees or to the industry, where employees are engaged less than 300. This will be a vital change which we see from the industrial perspective. Concept of FTs being brought in, fixed term employment. Earlier, although this practices was done by various industries, but it has not a much legal sanctity. Now, this in this labor reforms, FT is being recognized or given a legal sanctity, and the employer are now very much free to engage, and many welfare measures are also being derived or being given to this sort of employment. Then dispute settlement mechanism. Works committee and grievance committee, it was always there in Industrial Dispute Act. But in this new IR code, before moving to a conciliation officer, the dispute must route through the grievance committee. It is made mandatory. And this has given a employer as well as employee to just first discuss whatever the dispute you have, if you can resolve it within yourself. Earlier it was not mandatory, now it has been mandatory, and any sort of grievance or dispute must route through the grievance committee. Then strikes and lockout. Now, earlier, the notice for strike was for the public utility services sort of industry only. But now it has been mandatory for all sort of industry. If any employer wants to lock out his organization, or any group of employees or trade union wants to go on a strike, they must have to give a notice, 14 days prior notice, and other provisions are almost same. But this strikes and lockouts will definitely going to change by implementation of this new labor code. Accordingly, layoff and retrenchment and closure provisions, reskilling fund has been provided by the organization. When you are going to retrench any employees from your organization, you have to give the compensation plus a reskilling fund. This is a new sort of thing which has been added. Then compensation and welfare measures. This I have already said, the concept of floor wage is being introduced, which government will decide, and it will be any minimum wage which government will decide will be above this floor wage. And this floor wage will be defined on different regions of the country. Maybe more clearly we'll see when it will come in action, or when it will get implemented properly. And then engagement of contract labor. Engagement of contract labor, it is always made easy for the employer, just for various reasons. Engaging contract labor in different industries, the licensing or government has this increased threshold limit from 20 to 50, and no permission is required for engaging a worker where less than 50 workers, 50 contract laborers are engaged. And earlier, the engagement of contract labor in core activity was prohibited. But in this new labor code, there are some leniency given in engagement of contract labor in core activities. Core activities, although it is not defined, what are the core activities? It is the industry who has to define what are the core activities. Basically, for the purpose which industry is being set up. Apart from that, everywhere you can engage contract labor. But yes, in this new labor code, some leniency has given for engagement of contract labor. And this gig worker and platform workers, the concept of gig workers and platform workers is being introduced. And we know who are the gig workers and platform workers, where there is no direct employer-employee relationship, and those persons who perform their work or participate in an arrangement of such activity which is outside of the conventional way of doing. These we know they are the gig and platform workers, and nowadays it is very common. Hence, thanks to government who have given recognition to this sort of worker. And with this, I feel the most of the changes which industry is going to feel, I have explained. Now we are waiting to hear Mr. Sharma, who is father of this all reforms, who has just drafted and in the committee of this labor reforms. And it is always nice to listen him. Such a dynamic person. Welcome, sir. And thank you once again, Bharat Chamber of Commerce, for inviting me and just sharing my feelings or industrial perspective on this labor reforms. Thanks.
Slide change.
Thank you, Mr. Srivastava, for that overview. May I now request Dr. Omkar Sharma to make his presentation on the labor law reforms.
Thank you, madam. At the outset, from depth of my heart, I wish to convey my gratitude to the Bharat Chamber of Commerce, the office bearers of the chamber, for giving this opportunity to me to interact on the issues of the labor reforms. Though I find it very difficult to speak now, when already two eminent speakers have already covered each and everything. So whatever I wish to speak to you, already they have been covered. So I do not know that now what to speak. So what I planned that though already have been covered by them, by my colleague from West Bengal, Manisha, and my colleague from the Tata Motors. But still I have to do the justice to the mandate given to me, because all the way I have come from the Delhi. I am not a disciplined speaker. The organizers need to tell me the time or for which the time allotted to me, so that I finish my session well in time. Till what time I can speak? Any office bearer? Or you are leaving me to speak till 4, because at 6 my flight is there, so I am to move out from the hotel at 4. Anyway, I'm now having liberty to speak up to 4. Labor reforms, labor laws. Friends, labor laws are not new to the society. These are not the development of the something 16th century, 17th century, 19th century. Labor laws are as old as our civilization. We find the references of the labor administration, industrial relations, social security, even in the Vedic literature, in Vedas, Upanishads, Sahitas, Nitis, we find the references. Even I attempted to compile the references from the Vedic literature. Around half a dozen papers were published, penned by me, in the journals published in India and also published by International Labour Organization, Geneva also. Also, it is coming in the form of the book, maybe in another 6 months or 1 year, Industrial Jurisprudence in Vedic Literature. What we do have, the labor laws in Vedas. So these are not something new to our society. Though this kind of the labor law, what we have the labor law, first law came in 1348. We read in the history that in 1345 there was Black Plague in Europe, resulted in the death of the millions and millions people, most of the working class. So simple economics, law of demand and supply, when there was a shortage of the labor. So the price of labor, wages, the people started demanding the higher wage. Surprisingly to know that first labor law was anti-labor. First labor law was anti-labor, which came in 1348. What it talks? That maximum wage. So first ordinance on the labor was that no worker, trade union shall demand the wages higher than the rates which were prevailing before 1345, and no employer shall also pay the wages higher than that. What we do have now, Minimum Wages Act, the antithesis of the Minimum Wages Act, first labor laws was the anti-workers. And surprisingly, this law remains on the statute for 30 years. And in 1978, some relief was given to the working class, that when the prices were increasing, cost of living was increasing, but there was wage ceiling, wages could not be increased because of the law. So in 78, that too through judicial interventions, that some allowances was to be given along with the wage to compensate the increase in the cost of living. That was nothing but was the DA, what we get the DA, along with our wages in the government and IDA and VDA, etc. It was because of the 1348 law that was the maximum wage. See the importance of the reform, how we moved from the maximum wage to minimum wage. my friend was talking about the recognition of trade union, registration of trade union. See, during 14th century, there was the law. Forming of the trade union was banned. It was illegal. People were sent to the jails. Forming of the trade unions. So even the concept of the club came there only. That they were saying, we are not forming the trade unions. We are forming some club, and in the clubs they used to discuss the issues. In 1599, when Civil Services Act came in Europe, civil servants were not allowed to form the trade unions. Then they also moved to form the clubs. So now we officers are having the clubs. That too, that is also a trade union, which we borrow the concept from the trade unions. When they started forming, workers started forming the clubs. See, that is how we moved from the banning of the trade unions, now registering, not only registering, but recognizing of the trade unions. It's very interesting to trace the historical developments, and the reforms time to time took place. So we reached to this level, what we do have now, the laws. Coming straight away, not move talking about this, coming to the present scenario. First time, that is in 1929, the then British government set up a commission known as Whiteley Commission or Royal Commission on Labour, gave the recommendations, lot of recommendations. On the basis of recommendation, lot of labour laws were enacted. And then after independence, first National Commission on Labour in 1966, Justice Gajendra Gadkar, ex-Chief Justice of India, was chairman, gave the recommendations. Madam was referring to that of 1969. It gave the report, gave some recommendations. Then also some reform took place. Then in 1999, second National Commission on Labour was set up. I had the opportunity to work with this commission. And then they gave, that is, mainly 3 recommendations, which Madam also covered. That is, first is consolidation of labour laws. There, that time 44 central laws were there, in addition to the state laws. And consolidation of labour laws, the recommendation says, that is, the commission said, that is, there should be 5 codes. We have now 4 codes, but NCL said that is 5 codes. These laws should be codified or consolidated in the 5 codes. Then second was the simplification, right in a simple language. Madam was referring, that is definition, different definitions. As on date, we are having 16 definitions of the wage in different laws. For EPF, different wage definition. Minimum wage is different wage definition. Payment of wage is different. ESI is different, like so. So that's the simplify it. Then what is more important, the recommendation was, that is a rationalization of labor laws. A rationalization of labor laws. That is the important. Not so consolidation is not so important. Simplification is not important. What is that? Is rationalization. Rationalization. What is rationalization? That is aligning the existing laws, rewriting the existing laws to address, redress the contemporary issues of the employers and of the workers. That is the rationalization. Then what are their issues? Those are to be addressed. Working communities' issues and of course of employers' issues are to be addressed, redressed. Because lot of labor laws, now we are having that, still we are having the statute, 100 years old law. Employees Compensation Act 1923, Trade Union Act 1926, Payment of Wages Act 1936, even the when the Industrial Disputes Act is also pre-independence, April 1947. Minimum Wage Act 1948. Industrial Employment Standing Orders of 1948. So we need to revisit to redress the issues of the both partners, employers and workers, and of course of the government also. We are having appropriate government, that is whether the central government to administer the law or the state governments in different laws, different definitions. So those issues were addressed. So in 2010, May 2010, the government set up a council, Prime Minister Sectoral Innovation Council on Labor Reforms. PM Sectoral Innovation Council on Labor Reform. On 9th May 2010, a small responsibility was entrusted to me also. I was made the member secretary of this council, PM Sectoral Innovation Council on the Labor Reforms. So, on the basis of that is what is the recommendations of the second NCL, not only that also, but also the various issues raised by the employers at various forums, workers and trade unions at various forums. Those are to be, considering those, we were to go for the changes. As it is not simply the amendment, small amendment in some provisions. So we call it reform, as Manisha told, that is what is reform, but of course not revolution. But reform, it is not simply amendment. So 2010, May 2010, the exercise was started. And for last 10 years, over 10 years, 12 years, exclusively not doing much of and other job. I'm working on the labor reforms, writing that. But I wish to clarify, when my colleague Srivastava are saying, Onkar Sharma for labor reform, what he meant by saying it, that I am responsible for all mistakes. No. I am not responsible for all mistakes. Some of my other colleagues are responsible for the these things. It was, of course, drafts were prepared, but drafts were discussed, amended, changed. We had, that is, tripartite consultations, state government, employers, workers at a number of times. So a lot of changes were took place. Of course, to some extent, you can blame me also for all mistakes, but not I am the only person to be blamed for the all mistakes. Of course, if they are good things, give me the credit. I'm ready to accept the credits, but not the. Thank you for the compliments. Thank you for the compliments. So with this background, we'll see, that is, we will I will highlight some of the salient features of the various changes. Yes, there were 44 laws when we started this exercise in 2010. So we revisited. And then what we found, that lot of laws have become redundant, outdated. Not only the provisions of the existing laws have become outdated, even the laws have become outdated. And there were 44, 12 labor laws were repealed. Out of 44, 12 were repealed through the act of the parliament. So presently, as on date, we are having the 32 labor laws. And as 29 labor laws, we have consolidated the provisions of the 29 labor laws. 3 are there left. Let me tell you, one we are going to repeal the day we give the effect to these codes. That is maintenance of the records, registers, returns by the small establishment. That we are going to repeal. Rest are the two other laws: Bonded Labor System Abolition Act, another is Child and Adolescent Labor Prohibition and Regulation Act 1986. I'll not speak much on these two laws because my first book was on the child labor law only, that too before of my joining the government. So these, why people are asking me why you have not consolidated. Friends, we want to have child labor free society. We want to have the bonded labor free society. So this is why we don't want to have this in these. Maybe after 5 years, maybe after 10 years or 20 years, we will see that the society is free of child labor, free of the bonded labor. So this is why we don't want to continue having the bonded labor and the child labor. This is why we said that is we will repeal these two laws once we are having the child labor free society, bonded labor free society. This is the reason we have not consolidated the provisions of these three laws in that. So finally we'll be having, at present we'll be having, that is 29 laws plus 2 laws, 24 codes plus these 2 laws. And very soon we wish that at the earliest we will repeal the 2 laws, bonded labor and the child labor law. So finally we'll be having only the 4 codes. Sir, it is not working. सर मुझे ऑन करके तो देते, हमको ये मशीन चलानी नहीं आती इतनी. Multiplicity of labor laws to difficulties in the compliance. Yes. If someone asks me, Dr. Sharma, can you give the name? Can you put a name? Put the all 44 labor laws? I say no. And you expect the employer to comply with the provisions of the 44 labor laws. So consolidation. Maharashtra recognition of trade unions and prevention of unfair labor practices act. Friends, act का नाम है जो 3 लाइनों में आएगा. Very difficult even to remember the name of the act, and we expect that employers to comply. So we need to simplify also. Recommendations, requests. That is what is basically objects, what we said. That is aligning these laws with the present economic scenario. Second is every worker. Social security, wage security, health security, safety security of every worker. Srivastava was saying that is even if there is no relationship of employer-employee, still for them we will have the social security as gig worker and all. But only I'll take the call from which comes from my boss. I need to take. Compliance. What is the present time? Present time. My inspector will go and visit the establishment, will conduct the inspection, come out. Now we are adding one more responsibility to him, that guiding the employer in the facilitator. It's not only just you need to help the compliance. What is important is the compliance, not the importance of detecting the violations. And transparency and accountability in the administration of laws, that's also very important. Even which establishment is to be conducted, is to be inspected, that even my inspector will not decide. Sir, I am wearing the purana shirt पहन रखा है, the inspector is not happy with me. पुराना शर्ट पहन रखा है तो मेरा इंस्पेक्शन कर देगा. That discretion we don't want. That web-based list of the establishment will be there, generated, that is which are to be inspected. And it's not only we can have the changes, reform through changing the law. So we are putting it the legislative reforms, which we are talking about the 4 courts, changing the law, and second is the governance reforms. So we are using the technology also, that we are having Shram Suvidha portal, common registration, single return, common registers. Friends, when I was working on this issue, I was examining, that is 8 labor laws, only 8 out of 44. That is, under the 8 laws, Manisha will vouch, only 55 registers were to be maintained. Under 8 laws, only 55 registers are to be maintained. As if labor laws is to promote the business of stationery. Stationery का business promote करने के लिए क्या? So we reduced that time when I was working, reduced 55 to 5. Now we are working to reduce it to 1. Then universal account number, then we are having the e-Shram cards, registration, etc. And so many changes we have brought in. That is. Then these are the 29 list. 29 have been consolidated. My colleagues have already told you. Just what is the approach? This is the important to know. So you will find this in all 4 courts. So there will not be no need of repetition these things. What is that? To the extent possible, having the uniform definition. To the extent possible. Just we cannot have one definition only. Yes, to the extent possible, we'll be having the uniform definition. And also change in the administration of labor laws. Compliance notice before taking legal action. Presently, what is the law? My inspector will conduct the inspection. Inspection is, that is, compliance audit. To what extent that is laws have been complied. And if there is some compliance gap, so what presently law says, we will rush to the court of the law and file a case. Violation of labor law, that's a criminal crime. So criminal case will be filed for the violation. So we have made the changes. It's not, that is, legal action oriented inspection. We don't want legal action oriented inspection. Compliance oriented inspection. Inspector will say these are the compliance gap and you are being advised to ensure the compliance, to do the needful. And if you have complied with, please need to go for the filing a case against the employer in the court of law. Is there any need? Purpose was to ensure the compliance. So if that is that compliance notice before taking the legal action, one opportunity to be given to the employer to ensure the compliance. But of course, in some grave offenses, this may not be possible, may not be available. Then second is graded penalty. Graded penalty. Presently, in all 32 labor laws, the language of the punishment is, what is the punishment language? If the provision of the act or the rules are violated, then such offenses are punishable by way of fine or dash or both. in all 32 laws. Fine or what is or? अच्छी बात है क्या imprisonment? आप business कर रहे हो imprisonment. Of course, punishment has to be deterrent. If the inspector has come for checking the records, he is asking to produce the record, my concerned clerk is absent. So non-production of records. So presently, what is the punishment? Fine or imprisonment. Is it so grave offense when employee is saying, look here, today I'm not able to produce the register, my clerk is absent, tomorrow you come and conduct the inspection, or I will come along with my registers in your office. What is wrong? Certainly it is not so grave offense for imprisonment. Even display of the notices, non-display of notices. रात बारिश आई थी, सुबह बारिश आया था, वो नोटिस उड़ गया, टूट गया, फट गया, खराब हो गया, imprisonment. What is graded penalty? On the basis of the gravity of offense. Yes, in the courts there are also punishment by way of imprisonment, but only in the grave offenses. Only in the grave offenses. Not in every offense. The degree of punishment will depend on the gravity of offenses. We have for different violations of provisions, different. Even the fine is also from 10,000 to 8 lakhs, depending on the gravity of offense. So that is the graded penalty. In all courts, you will find the graded penalty. And of course, in the first offense, only the fine, and the subsequent offense, then to check these things, that is to discipline the employer, then you need to have, that is, some deterrent punishment. And then the other is composition of offense, compounding of offense. What is compounding of offense? This you will find in all 4 codes. If punishment is by way of fine, presently, even the fine is imposed by whom? By criminal court of the law. Fine is imposed by the criminal court of the law. And if employer says, look here, yes, I confess that there was violation, take the fine from me. Why you are asking, why you are going to the criminal court and filing a case in the criminal court of the law? So that is decriminalization of the labor laws, decriminalization of certain offenses. If fine is there, so what we have in the provision, if you are ready to pay 50% of the fine, 50% of maximum fine, just deposit the 50% of fine, matter will come to an end. No filing of the case in the criminal court. That is the composition or compounding of the offense. So that you will find in the all 4 codes. Of course, if offense is very grave, if there is violation which resulted in the death of the worker, disability of the worker, of course, then there is it's a very grave. So there can be the case will be filed in the criminal court of the law, but other cases, it will be decided by the officer, not by the court. Only cases where that is punishment by way of imprisonment will go to the criminal court, and if it is provision is only by way of fine, it will go to officers. Officers will be notified by the government and they will dispose of the case. That's the decriminalization of the labor laws. then this is what responsibility to guide the employers. That is basically labor department. We are to ensure the compliance. Hand-holding also. Hand-holding of employer, help the employer in the compliance. We are giving, that is, we are giving more responsibility to inspector, not only inspection, but also helping the person for the compliance. Even that is, this is what that is, which establishment is to be inspected, that also the schedule will be generated through the system, and that too we have developed a system also in the central government, that is on the basis of the, if suppose on the basis of establishment, nature of work performed, etc., then probability of frequency of coming of that establishment for inspection we have developed that software. What we do have? Computerized, randomized selection of the establishment, and also transparent. Inspector will upload the inspection report also on the website, and that too within certain period, within 48 hours or 24 hours, whatever it is, the government will decide. Using the technology, that is registration of the establishment, Shamshuddha portal, what we are in web-based inspection, licensing, contract, etc., permission, all. Friends, we don't want you to come to our office. हमारे ऑफिस में हम आपको बिल्कुल भी नहीं बुलाना चाहते. All will be online. Application online for registration, for licensing, for filing the return, etc., etc., etc. Everything online. And also we are working. We are still working. Don't quote me that this is going to happen. We are still working. Faceless inspection. We don't mind even my inspector to visit your establishment. We find in some parts of the world this kind of the system also. Let me also tell you, that's not related to, but it's just I wish to inform you that we tried to embed the best practices, good practices, which are prevailing in any part of the world, to the extent possible. Friends, we are having ILO, she referred to ILO, International Labour Organization, came in 1990. They set the standards. International laws are known, international labor laws known as 3 instruments are there. That is conventions, recommendations, and protocols. These are the international ILO conventions, international laws. It's set up in 1919. After every 40 years, 50 years, or they also revisited. They also need that is reform. It is not what was conventions was set up 100 years ago is still good. No, society is changing, so that we need to change the standards, labor laws. So in 1973, they revisited, they did first reform, international labor reform in 1973. And again, they did this exercise and they set up a 27-member committee, tripartite, 9 employers representatives, 9 workers representatives, 9 government representatives representing 192 countries, 192 member countries. And I had with you people blessing, I had the opportunity to be a member of this committee where we revisited these international labor standards. In 2015, they set up the committee. I was one of the 9 members representing the government of 192 countries. So I had some opportunity to understand, to develop some understanding of the what is the law, what is the practices, what are the standards prevailing in different parts of the world. So we used to have every 3 months, every 4 months meetings in Geneva. I had to travel 4 or 5 times to the Geneva all the ways. And not only some meetings took place, not only all meetings used to take place in the Geneva, but also in some other countries, some other cities also. So that time, that is also I was associated with the not only labor reforms at national level, but also at the international level. And also I had also opportunity. ILO is having the program, they have identified some people, and also they have given this responsibility to me also. I'm part of some of the committees of the ILO. They used to have that is sharing of good practices. So ILO used to take me to the different parts of the country, world. So where we used to tell that is what are the good practices, what India is having good practices, and we used to learn what that country is having. So this way, I some extent I had the opportunity to have that is what the other countries. Why I'm saying it, friends, we tried to embed the good practices, the good standards, good schemes, whether it is administration or whether it is labor laws are nothing but the standards. So we try to extend to the extent possible to have these laws containing the good practices. So what I was saying, the faceless inspection, that in Lisbon and Madrid, when I was there, so there I learned that is what way it is, how it is practicing. Of course, in the working conditions laws, it is not possible. But in the rest, because now everything is now digital. So every record is digital. So maybe except for the working condition law. Working conditions में तो establishment में जाके ही देखना पड़ेगा. But in the rest, you may find it after 5 years, 10 years, or 2 years, faceless inspection also. No inspector will visit, as we don't want you to come to our office. Also, maybe that we will also not visit your establishment. Everything will be online. That is also we will move. We are still working on that. This already we have told. Since it is not consolidation, doesn't mean that it's 29 books in the one big book. See, that is e-forms. How many we were having the sections? 1232. And now it is around 1/3 only. So it is not only consolidation. So we have that is number of provisions have reduced from 1200 to this number. So also, I'm sorry, I again repeat sir, but madams are also there. Though in General Causes Act it says he includes she. So I have taken that is sir includes madam also. Please don't mind. What we did when we started this exercise, friends, we had the wish list of the employers. Wish list of the what you want. And also we had the wish list of the workers also, trade unions also. And believe it, we made it very clear and sincerely, honestly, we worked to accommodate each and every wish of industry and employer, each and every wish. But without diluting, without compromising the rights and interests of the working class. All your wishes you will find here, but that too Only constant was without compromising the rights and interest of the workers. ऐसा विश लिस्ट हम नहीं मानेंगे जिससे वर्कर्स का इंटरेस्ट अफेक्ट हो. But rest, whatever you have the good governance, you will find it also. Punishment, this, that, inspection, etc. All you will find. All we have accommodated. President of the chamber said, yes, we want to, even you don't want to have that is, you want that is ease of doing business, but along with ease of life. Ease of life also. Like workers' interest, you are also concerned. तभी तो वो आपके साथ काम करेगा, best productivity देगा. So that is, you will see that all these are the wish lists we have addressed. For drafting these, committees were set up. In 2014, though we started working from 2010, so committees were set up to draft this. A committee was set up on minimum wages, drafting of the wage code on wages. One-man committee. I do not know whether committee can be one man, but it was one-man committee. Onkar Sharma was the only person in the committee. Name is committee, but there was only one person. Then on industrial relations, again a committee was set up on 13 February 2014. Two-member committee. Onkar Sharma and another my colleague was there, S.C. Sharma. And S.C. Sharma retired on 28th of the February. 13 February, committee was set up, and on 28th, the other member was. When I said, sir, no, madam, that time Gauri Kumar, our secretary, was there. No, somebody, there should be committee means something. Some other person, okay, you want that is, there should be another member. Yes. So S.C. Sharma was made the member, and we had very important meeting. Only one meeting, he said, this is Dr. Sharma, my first meeting and last meeting with you over a cup of coffee. We discussed so many issues. And that was and then there was the third committee was set up on OSH and working conditions code. Again, I said, no, we need some technical pupils also. In that committee, mainly three members were there. We were assisted by others. Onkar Sharma was the member convener. Another member was DG Fastly, Director General Factory Services, because technical health and safety, I was not well versed. So we got the input from the other member on the health and safety, and DG Mines Safety on the mining laws. So that also we got the input from the DG Mine Safety. So mainly three members were there in the OSH code. I was only the member convener. I made the draft, but input I got from the two technical experts. And there was also Social Security Code. So Social Security Code, it was not only, there was committee having the representative people from the EPF organization, ESI organizations, and also from the state government, and also some other officers. And I was only one member of that. So सबके लिए मैं जिम्मेवार नहीं हूँ. सोशल सिक्योरिटी कोड में 4 लोग और भी थे. Very briefly, how much time I can have? Anybody, any organizer is here? बुला के खुद गायब हो जाते हैं. कहाँ हैं वो organizers? Up to 4? What is the lunch time? Okay. So you are saying that is half an hour only. Eh? Half an hour. Half an hour. Okay. Thank you for the compliments, sir. Thank you. Wage code, very briefly, because now in 10 minutes, all 4 codes, 5 minutes, I'll be spending 5 minutes only. Wage code, consolidation of provisions of 4 laws, Minimum Wages Act, Payment of Wages Act, and Equal Remuneration Act. And also the bonus is deferred based to Payment of Bonus Act. What are the main change reform? Payment of Wages Act. Friends, it's a very small law. Payment of Wages Act 1936. It talks only of 2 things. Timely payment of wage and payment of earned wage, full wage. That is without any unauthorized deduction. You can make the deduction of income tax, of my provident fund contribution, ESI contribution, etc., which are given in the law. So my salary is 20,000 rupees. Out of 20,000, you deduct income tax, EPF, etc. Give me 18,000, 17,000, 16,000 rupees. And timely payment, when the wage period is over, you pay it. This is 1936 law. Such a wonderful law. But if it is a wonderful law, it is applicable to 6 places of work. Only applicable to 6 places of work. What are those? Factory, mines, plantation, transport, construction, oil field. Is the hotel a factory? No. Mine? No. Plantation? No. Transport? No. Oil field? No. Construction? No. So Payment of Wages Act is not applicable. So employer will decide whether to pay or not to pay, or when to pay. And then it had the wage ceiling also for coverages, 24,000 rupees, up to 24,000. Wage is to be given. Who are covered? Only 6 places are covered, though under section 2H, central appropriate government have been empowered to add more in that more industries in that list. West Bengal have added number of industries, but law says only 6 places. I am a student of labor law. I'm yet to understand what is the labor law. Yes, madam, believe it. You are talking about the labor reform. I'm yet to understand what is the form. What to talk about the reform. I'm yet to know what is the form of the labor. But you people are very nice listening to the person who doesn't know even the form, that too of reform. I asked in 1985 when I started studying the 84, 85, studying the labor laws to my professor, Professor B.T. Kaur. Sir, why this is only for the 6 places of employment? He said, this is the law. Yes, sir, this is the law. I'm asking you why. It is given, he read the section, such and section that is in the applicability. It is mentioned in section 2, section 3, like this, it is applicable. He read the law. I said, this is okay. I can read also, you are reading. But why it is? He says, gentlemen, I am to teach you what is the law. I am telling you this is the law. That's all. This is my understanding. That time I was so confused. There is a Minimum Wages Act also. It is applicable only to the scheduled employment. Even I asked my professor, what is scheduled? It is given the schedule is the list, etc. I said this much. language I also know, dictionary meaning you are telling me, but why it is applicable to schedule and not other? He says, I told you yesterday also. This is the law. I am supposed to teach you the law. Only what is given in the. In 92, I joined as Assistant Labor Commissioner. Before that, I taught for some time in Delhi University. For a few years, I taught Delhi University, then I shifted to the government. In 92, as Assistant Labor Commissioner, I asked I got one opportunity after a few months to talk to the Chief Labor Commissioner. For the country, there is Chief Labor Commissioner, one Chief Labor Commissioner for the country. I'm yet to become the Chief Labor Commissioner. Though Prime Minister has cleared my name, maybe I'll get that. Thank you, thank you. Thank you. But still, I'm not the Chief Labor Commissioner. I'm waiting. My senior is to retire. The present Chief Labor Commissioner is to retire. Then I'm to. Government has cleared my name. I may get it. लेकिन अभी नहीं हूं मैं. So I asked my boss, super boss, sir, why? He said, this is law. Surendra Nath was the Chief Labor Commissioner. I repeated the question. I got a good scolding. What? I have told you this is the law. Don't ask why. Don't waste your time. That day I learned first lesson in the government or in the employment. What the lesson was, you can repeat the questions to your professor, but not to repeat to your bosses. Not to repeat your question to, and not to ask the difficult questions to your bosses. Bosses are supposed to ask you the difficult question, you are not supposed to ask. Confused, totally confused. Even I do not know as on date why it is scheduled, why it is applicable to 6 places of employment, why there is a wage ceiling of 24,000 rupees. Still I do not know. When one member committee was there and I was having the mandate to draft a law, I removed these 6 places, I removed the schedule, I removed the wage ceiling also. In the wage code, no wage ceiling. Thank you. No schedule for minimum wages and no list of the establishment where Payment of Wages Act will be applicable. So any person, what is the word which is used as employee? Employee. So wage law says employee or employers. Either somebody is employee or somebody is employer. Worker only for the purpose of the dispute which is raised for the bonus, payment of bonus. Otherwise, for the equal remuneration chapter, for payment of wages chapter, and for the minimum wages, no word is workers. सर इतनी आसानी से मैं कंफ्यूज नहीं होऊंगा, आप मुझे घुमाओगे नहीं. So now universal, every employment, every employee is covered under the Payment of Wages Act, wage security along with the minimum wages also. How many of you are employees in this hall? How many of you? देख के हाथ उठा रहे हो, पड़ोसी ने उठाया है नहीं. So if the employee is getting 5 lakh rupees per month, whether working in any place, he is having now right guaranteed under the wage code, timely payment and full earned wage. So all employees have been given first time, that is right to wage, including right to the minimum wage. See the change, see the reform. This is why Manisha said that it is not amendment, it is the reform. You will appreciate it is the reform. Even it was not so easy. It was not so easy. Why? They're saying, no, minimum wage has to be. I said, that is when minimum wages is fixed on the basis of calories, minimum calories required to keep the soul inside the body, 72 yards cloth, some provision for housing, 25% or 20% of overheads. नॉन शेड्यूल्ड के लिए नहीं ये रिक्वायरमेंट है, उसको भूख नहीं लगेगी, उसको 2700 कैलोरीज नहीं चाहिए है, कम भूख लगेगी, शेड्यूल वालों को ज्यादा चाहिए, बाकियों को if someone is having the 25,000 rupees, employer say I'll not pay you. What? He's not covered under the wage law. Madam is very brilliant, intelligent in law. She will definitely say yes. She has the remedy. He can go and file a civil suit. Madam, how many decades it will take to the civil court to decide? How many? Decades. You must be knowing that is these private schools, they call them as public school. I do not know why they are calling them public school, private. What wage the salaries the teachers are getting there? कितना मिलता होगा उनको? 15,000, 20,000 private college people are giving to professors. Yes, this is fact. There was a group of ministers was there, GOM was there on the labor reform. Arun Jaitley was the chairperson of that. When I was making a presentation before the group of ministers chaired by the Arun Jaitley, so it was opposed. Even my ministry opposed. My secretary was opposing. So we do have in the draft, but we may think of changing it. Then Arun Jaitley, he said that why it is. I'm having in my machine one advertisement, copy of one advertisement of where there were 2 posts were advertised by some education institution, lecturer chemistry, salary 7,000 rupees, and another post was of sweeper, salary 9,000 rupees. Sir, abhi tea break mein dekh lena, chai lunch break. I showed this advertisement to the Arun Jaitley. Sir, we want to have this kind of the practice because that is law-abiding institution. Minimum wage for the housekeeping, which is in the schedule, was 9,000 rupees, and teachers are not in the schedule. So give 4,000, 2,000, 5,000, 8,000. And yes, I was supported by the Arun Jaitley. He said, yes, nothing wrong. We can have this should be. Sir, we are talking of minimum wage. We are not saying that is how may wage in lakhs and millions you have to give. Only we are talking of the minimum wage. That too based on that some things. That is on that is experience, etc. Even now the young boys and girls who are doing BTech, MTech, MCA, what they are getting in the private sector? Of course, people are getting in the labs. Sometimes people used to come to my office. Sir, my parents paid 20,000 per month the fees to the college, and I'm getting the wage or salary employment of the 15,000 rupees. 20,000 फीस दिया और नौकरी कितने का मिला? 15,000. So now you will see that this is the change in the wage guarantee, that is this thing. And then also national floor wage. just to discipline some of the indisciplined states. मैडम मैं वेस्ट बंगाल की बात नहीं कर रहा हूं, किसी और स्टेट में जाऊंगा तब वेस्ट बंगाल की बात करूंगा. You are a disciplined state because I am in the West Bengal. Yes, so we'll be having a national floor wage, and no state will be allowed to fix the rates of the wages less than this wage, which will be decided by under the law. Of course, we'll decide how we'll decide that is wage also. This is already clear. Now it is applicable to the specified notified industries, 24,000. Now apply to all employees and all establishments. It is not enough, sir. It is not enough. And you see, that is my younger brother, working in one IT company, what HCL, etc. Morning timings are fixed, 9 or 10. In the evening, when people are to be back at home, around 11 at the night, generally we get the call, "Bhaiya, aaj main late aunga." If he is coming the same day, then he is not late. If he is coming next day, then only he is late. Yes, that's also we need to check. We are not saying that is what wage. You are deciding the wage. You are deciding subject to minimum wage. But wage should be for a fixed hour, working hours. That is normal working day. You decide that is 8 hours. Generally, it is 8 hours. Section 14, if you read, what it says, if someone has what? Employee. What is definition of employee? Anybody is having? Employee means skilled, unskilled, semi-skilled, clerical, operational, manual, supervisory, managerial, administrative. सभी को कवर कर दिया इसमें. खाली किसको कवर नहीं किया? एम्प्लॉयर. एम्प्लॉयर को छोड़ के बाकी सब आप जीएम हो, वाइस प्रेसिडेंट हो, आप भी एम्प्लॉई हैं. If any employee is working for more than 8 hours, he is to be given the overtime that would be double of the normal wage rate. जो एम्प्लॉइज हैं वो तो ताली बजा दो. What is wrong with that, sir? Law, that is 8 hours. Even that is, I am not Superman. Even though I am a manager, does that mean I am a Superman? मुझे 8 घंटे सोना भी है, 8 घंटे मेरे को और काम भी करना है, 8 घंटे मुझे, that is scientific. Doctors say that is working hours. Once a while it is okay, but it cannot be regular. And once a while you compensate if you are asking someone to work for 12 hours, 10 hours. What is wrong with that? So section 14 says that too also for the overtime if someone has worked for more than 8 hours. Then also you will see presently what is the law in case of non-payment or short payment. A claim is to be filed before the authority, some deputy labor commissioner, assistant labor commissioner or labor commissioner notified by the government. Who will file the claim? The employee who has not been given the wage. And presently he is to prove to the authority that I have not been given the wage. This is the law, I don't know. As authority, I'm having the exposure. I worked as authority. I'm in the labor department. Very difficult, sir. If you have not given me the wage, how I will prove that I have not been paid wage? Do I have any document? Do I have any voucher? Do I have any record registers? Now what it says, that burden to prove presently is with the claimant. Now burden to prove will be employer. You are having the records to prove that he has been given the wage. So you want to prove you are innocent. So Baba goes to prove that he is innocent. Otherwise, he has to be in the Bapu or Baba has to be in the jail. So that also now, that is employer to prove that he has been paid. Why I am saying, please keep your records registered. For not 3 years, after the 3 years, there can be limitation period, condonation of limitation period. And presently it is 6 months. Within 6 months, you have to prove, you have to file a case. Sir, what you expect me just to rush to the authority if I have not been, there is a delay. Certainly. Employer gives the assurance, I accept it. Assurance, okay, I will give you that date, this, that day. And then if 6 months are over, it is time barred. Now limitation period is of 3 years. Not only keep the records for 3 years, but also the madam can condone the delay. And sometimes see the last one. Employer is also an employee sometimes. Your occupier, factory manager is occupier, he is the employer. But if the owner has not given the money to the factory manager, occupier to pay the wage, sir, वो कहाँ से wage देगा? Every employee is not so rich कि वो 200 आदमियों को फैक्ट्रियों का पेमेंट अपने घर से. Now, if the employer has failed to pay, then owner is to pay the, owner is having the liability to pay it. Is it? So, these are some salient features. These are the reform in the wage. Now, coming to the OSH. What is the biggest reform? Only how much time I'm having still? घड़ी ठीक नहीं है आपका, अभी 5-7 मिनट तो हुए हैं, only 10 minutes. Continue. मैडम इनको भूख नहीं लग रही है, कोई सो भी नहीं रहा है. OSH. Let me, in 5 minutes, let me complete it. In 5 minutes only. In the OSH law, as madam said, that is 9 provisions of 9 laws have been 13 laws have been consolidated in OSH. Presently, we are having the law only for 7 places of employment. What OSH working conditions law says? It talks about the safety and health and working conditions. Working conditions says working hours, weekly off, paid leave. These are the 3 things of the working hours, and some reasonable comforts at the workplace. Pani pila do, rest, etc. Some amenities is to be provided. These are the working conditions laws. Presently, it is applicable only to 7. We are having Factories Act, we are having Mines Act, we are having Plantation Act, we are having Dock Workers Act, we are having Motor Transport Workers Act, and then we are having for the BD workers for working conditions laws. बाकी जगह के लिए हमारे पास नो लॉ. आपका स्टेट का शॉप्स एंड एस्टेब्लिशमेंट एक्ट है जिसको आप अमेंड ही नहीं करते. दिल्ली शॉप्स एंड एस्टेब्लिशमेंट एक्ट इज देयर, इट केम इन 1952. If any provision is violated, punishable by way of fine up to 250 rupees. आपके यहाँ भी ऐसा ही होगा है? 100 रुपया भी फाइन है, वो भी ज्यादा है. up to 500. एक पान वाला भी कहता है कि मेरे से रोज 500 रुपए ले जाया करो, मेरे को डिस्टर्ब मत करो, 500 रुपए हर रोज फाइन दे दूंगा मैं. बड़े बड़े मॉल्स हैं, शोरूम्स हैं, बड़े बड़े शोरूम्स हैं. Whether 250 rupees or 500 rupees matters to them. Can we Can we ensure the compliance? No. Certainly no. So, first of all, the biggest change is now this law would be applicable to each and every establishment. And if you read the definition of establishment, you will find every workplace is included. Health and safety, do we need to compromise? Why it is only to the selected places? So now working conditions, health and safety provisions will be for all. Every establishment employing 10 or more. 10 condition is there. ESI 10 condition is there. Madam was saying that why 10? Why threshold 10? Certainly, I believe I agree with Madam that threshold should not be there. But we are having presently limited resources. ESI is having limited resources, cannot cater the needs of each and every one. State governments are having the limited resources, but we will move to the zero employee also. Zero employee also. Sir, employer, the person who is running a small shop without any employee, don't we need to protect? Usko ek din ka chutti chahiye na? This is why we are having the Shops Establishment Act applicable even at zero employee. Usko ek din ka chutti do. Ek din wo shop band rakhega. We will move it. We will move maybe in the next reform, but don't entrust such reforms to the person who doesn't know the form of the labor. So first is this, 7 sectors ke liye hai. And what is that is what we are having. Another she referred to delegated legislation. What we are having, what is the second reform? I'll be skipping the rest, all these things. What is the second reform in this? We are having Factories Act 1948. You are well versed with that. It says from section 11 to section 20, it talks about the health. 21 to 41, A, B, C, D, E, F, G, H talks about the safety. And then 43 to 49, it talks about the welfare. Could we avert the Bhopal gas tragedy? Can we, with this present Factory Act, can we ensure the safety of every workplace, every factory? Different workplaces are having different health hazard, safety hazards. In chemical industry, it is different health hazard. In mining, it is different. In fabrication, it is different. In electricity generation, that is also a factory, it is different health hazards. Construction, it is different. We cannot have one of safety provision from section 21 to 41 and can ensure the safety of every person. Certainly no. So you will not find in this safety provisions. No, you will not find safety provisions. You will not find health provisions also in the OSH code. We don't want to draft it. We don't want to put it. This is, I learned from some of the countries. What is, now we are going to have the National OSH Board, National Occupational Health Safety Board. And so the State Occupational Health Safety Board, they will be having different committees, subcommittees from the different industries, representing the different industries. Having that is technocrats, bureaucrats, employers representatives, workers representatives. And they will suggest health and safety standards. They will suggest the health and safety standards for different industries, different standards. We cannot have just one standard applicable to every. And we are not again putting it in the main law. If we have to amend that law, we have to go to the parliament. After Bhopal gas strategy, not even a single amendment has been done in the Factories Act. कब हुआ था भोपाल गैस स्ट्रेटजी? तब 41 A, B, C, D जोड़ा था. After that, maybe 34, 40, 50 years हो जाएगा, 40 years हो गया होगा, 35 years. Friends, a lot of new technology changes have taken place. New methods, new technology we are using at the workplace. And when new technology we are bringing, new technology brings new hazards, new safety hazards, new health hazards. So we need to update these standards to cope up with the new hazards, This is why that is we will be having the regulations as recommended by the forum, this forum that is having technocrats, etc. They will suggest the changes, and then we will keep on amending it, revising it without going to the parliament for making the amendment. That's going to be a flexible legislation. And then other things, this is what dynamic, flexible legislation with board, etc., standards, rules, regulation, etc. That is, and also you need to have that is to give the employment letters also, just to formalize it, and also that is annual health checkup also. These are the very simple things. I'm quitting it. I'm quitting. Time is not permitting me. How much time? Over. Okay, in 5 minutes. So that I can say that I have covered the all 4 courses, but I'm not happy, I'm not satisfied, but still just to say that is I have covered, that is we have made the changes here also, that what we do have, that ESI, that also presently it is only for notified districts. Now it will be applicable to 762 districts, all. And then also in the hazardous industries, that is, it will be applicable even for 1 worker, not only for 10 is there, it is. Then what we are having, universalization of social security. Universal, it should be. That for the organized sectors, what we are having, EPF, PF, etc., and the new pension scheme, etc. For rest of that, then what we have created, that is even gig workers, also we are having, that is schemes, etc. We are working on that. Most of them, about every day I spend a lot of time on the drafting of the schemes for the gig workers. Even I reached here yesterday at 9, and at so 2 hours, 2.5 hours, I worked on the scheme of the gig workers which we are going to finalize. Then also in the inaugural address, PM SIM, Prime Minister Shram Mandhe Yojana, that is for the unorganized sector, pension is there. So we are covering these also. Then also social security fund is there, which will be used for gig and platform worker, it is there. And then also some changes, these, what you can read it, you can read that also. Time is not permitting me to go for the, then we are having industrial relations code. Lot have been covered. Time is not with me. Only what I'll say on few things about the fixed term employment, FTE uses. FTE, though we do have a provision of FTE, something similar to in the existing law, section 200BB, retrenchment. Non-renewal of term of employment is not a retrenchment. Now we are properly saying you can have the work employees for a fixed period to address your issues of the flexibility. You generally you go for the contract labor just for the purpose of the flexibility. Sir, मेरे पास आज काम है, कल नहीं होगा. Just to address the issue of the flexibility, we are going to have you can have the workforce only for a fixed period. But a condition is there, wage parity, working parity, etc., etc. What you are giving it to the regular workers, permanent workers, same wage, same social security, same working condition, you need to provide to the FTE. Not at the call of, not to exploit. एक तो आप पहले ही उसको टेम्परेरी रखे हुए हो और ऊपर से आप उसको पैसा भी 50,000 की जगह 10,000 दोगे. So that's wage parity, etc. You have to do that. You should not have two things. Flexibility also and exploitation also. Please don't mind my words if I say exploitation. All here are, that is, I have great regard, respect to all of you. There may be 1%, 2%, which you will also vouch. There can be some indisciplined employers just to discipline them. So we are saying you cannot have both things. Either you can have the flexibility, if you want flexibility, but not at the cost of the workers' wage, etc. That's we are having FTEs, wage parity, no exploitation, etc., etc. This is already covered, my colleague. Recognition. In the central law also, we amended the Trade Union Act in 1948. Added section 25 recognition provision. Amended in 1948. Yet to be notified. Effective date is yet to be notified. Then we'll be having only one tribunal instead of labor court and tribunal, and it will be having two members, one from the judiciary, another you will find the Manisha ji there also. Yes, for the Manisha ji, we want that Manisha should also be there. So एक judiciary का होगा, एक administration का. Bureaucrat सभी नहीं जिसको labor laws का experience है. ऐसा नहीं कि IAS आ जाए मैडम की जगह. 2-member committee, second from the administrative side. Then threshold is to be decided by under section 25B. But to the state appropriate government, you can have 300, even you can have more also. Standing orders, etc., etc. Thank you very much for listening so patiently. Thank you very much. Time constraint is there. Hari Ananta, Hari Katha Ananta. फिर कभी समय मिलेगा तो ज्यादा कथा करेंगे, चर्चा करेंगे, but within time constraints. And also very thankful to all of you for listening so sincerely. Thank you very much.
Sir, we are already looking forward to the next time when you are here. So we will have another exhaustive presentation. Friends, I don't think after the presentation made by Dr. Sharma, there would be any questions. But in any case, if there is a question, then we could allow 1, 2, 3 questions. Yes.
Actually,
simple question, not a question.
no, actually you told ki Child Labor Act.
Child and adolescent labor.
Exactly. I'm coming to that. Child and Adolescent Labor Prohibition and Abolition and Regulation Act that is introduced in 2016.
Yes.
But you have not included Child Labor Act 1986 in these codes because you want to, because we all want to have a child labor free society. Then why adolescents are included in that and it will be continued? Then why they are not included in any of the labor laws?
We don't want even adolescent to continue. If you see child labor, child conventions, CRCs, etc., you will find that is anybody young or adult. Young means below 18 and adult means above 18.
Certainly, first we'll be making the child-free society, then we'll be having the regulation and will then move that is prohibition of the adolescent worker.
Actually, the problem is that
And another thing, see the definition of child.
definition
what
of
it
child
says,
is also.
it is not 14. 14 or the age as given as decided by in the
Right to education.
Right to
No, sir,
education.
what I want to say is that presently this child or say adolescents are working, but they are not covered under any of these laws. So what was the problem for child labor also? They were working, but they are not getting facility of any of the labor laws. Like for that period, say one person is working at the age of 17. He introduced into an industry which is not hazardous. He is working there. That 1 year, will it be included while paying the gratuity? It's not clear.
Yes. In the definition of employee workers in the 4 codes, you will not find that is age. You will not find that is age. Even if 16 years old is working because law permits in the non-prohibited category. So he is a worker like other. So he will get the gratuity, he will get the same wage, etc., etc. So we have not said the workers' definition, we are not linked it with the age. We are not linked with the age. And even if someone is of the 12 years old, if he is working, we will ensure the wage. Ensure that he should be paid, plus the employer should go to the jail also. Yes. Yes, sir.
Like advantages of codification, like one registration, one license, minimum forms, like that. You have one. You also said that there is a reduction in compliances code, a reduction in compliances cost. Whereas you are seeing in meeting the compliances, you are paying 4 times more than that limits, whatever been fixed. Like if you go for obtaining some licenses, explosive license, even you go for this trade license, whatever related licenses, you are paying more than the 3 times, 4 times. That government is increasing the cost drastically. So where the reforms, how your committee is working on it, minimize the cost.
I'll restrict to labor laws only. In the labor laws, we have not still fixed even that is the fee for the license. And presently, if you see the fee of the license, how much? It is in 2 digits, 3 digit also. So don't have an explosive license is not given by the labor department. When the appropriate government will fix, they will fix it very nominal, very nominal. Don't have the fear that is we will be having very big amount will be taken.
It is not fear, sir. As of now, the licenses considering the market scenario, licenses cost or the registration cost increased in all the ways.
Maybe there may be very nominal, only few hundred also. Because now it will be online only. Some fee is required. And another thing is what is in the license, if you see, now we are going to have the common license. If you are in a factory, license under factory and license under contract labor, you can have the common license. And that too, presently you have your license is only in the CLR Act is only for 1 year.
Yeah.
And after that 1 year, it is either you have to renew it or you have to, and also for the every work order, you have to have the fresh license.
Yes.
And contractor is same if he has taken the 5 work. So for each you have to, now we will be having the license holder with 1 license. You can supply the contract labor to hundreds of the establishments, thousands of the establishments. Big reforms in the license also. You are not giving me the time to talk about the license, etc. Madam is restricting. Oh, you are free to talk to up to any time, but 2 p.m. So listen me sometime on the license.
Thank you very much. Thank you, sir.
One and also all India license. All India license. You can work. You can supply the workforce anywhere in the country. So we are bringing that is when I'm saying, please believe that compliance cost will come. Please believe. Appropriate government, generally you will find appropriate government that is in the what we are having at present, the Industrial Disputes Act, with some small changes in all 4 courts, same is the appropriate government definition. Very tough question. To you, it is easy. To me, it is tough. To you, it is simple, no? To me, it is tough. No,
I
because
think,
because the person is recording, so I'll not speak on the camera. Off the camera, I will tell you.
Thank you, Dr. Sharma. And I think the rest of the questions can be discussed during the lunch. Please.
We are having pension regulatory authority. They are regulating this pension. That we have not made changes. We have not made any change in the present pension scheme under the EPF. Higher pensionary, it is before the judiciary. You are talking about a Supreme Court case. How? Yes, circulars are coming, etc. That is also, but Provident Fund Department has given circular that you have to for the implementation. Another thing is I do not know what will be happen. Supreme Court has gave the judgment, and after the judgment in last 6 months, Supreme Court has admitted 7 another SLPs on the same issue. So I am confused. So the Supreme Court is also confused. They have given the judgment, still they have entertaining going to examine the 7 another SLPs against their order. So that is circular issued by the EPF organization is okay, clear that it's very clear. They have given the time.
You have made this reform, leader. Now, my question would be, how you will comment whether this reformation, after reformation, whatever code we are having, whether it is balanced or pro-employee or pro-employer?
I made very clear in my session. We tried to accommodate each and every wish of the employers and industries, but without compromising, without diluting the existing rights of the working class. And I should not be the judge to decide it whether it is balanced or. Please read the 4 codes. Of course, something you will find that is that issues. It is issue of workers, some of the employers issue. To me, we try to have the balance.
I would now request Mr. Naresh Pachisias, Senior Vice President of the Chamber, to deliver the vote of thanks.
Dr. Sharma, Srimati Bhattacharya, Shri Srivastav, members of the chamber, participants, guests, and friends. At the end of this very interesting conference on labor law reforms, it's my pleasure and privilege to propose a vote of thanks to our honored guest speakers. At the outset, I would like to extend my sincere gratitude to our guest-in-chief, Dr. Onkar Sharma, Welfare Commissioner, Central Ministry of Labour and Employment, Government of India, for kindly sparing some of his valuable time in coming all the way from Delhi and addressing us and sharing his valuable thoughts on the recent reforms in labor laws. It's very heartening to know, sir, that after assuming this latest responsibility, it's the first time that you are addressing a chamber and you have selected Bharat Chamber for that. Thank you very much. And we look forward for more such interactions with you. Despite drawing criticism from the trade unions and other agencies, the new labor code is a much needed reform that can help improve working conditions and benefits of the workers in India, especially in the informal sector. However, it is important to ensure that these codes are implemented in a fair and equitable manner, and that the concerns of all stakeholders are taken into account. I now wish to thank our guest of honor, Srimati Manisha Sarkar Bhattacharya, Director, State Labour Institute, Government of West Bengal, for gracing the occasion and highlighting her perspectives on West Bengal in her address. I also thank Shri Rajiv Srivastava, Deputy General Manager, Tata Motors, Jamshedpur, for sharing his thoughts and insights from the perspective of the industry. My special thanks are due to the Eastern India Corrugated Box Manufacturers Association, Anjali Jewelers, and Rahi Infratech Limited for their support that they have extended to the chamber in successfully organizing today's conference. My thanks are also due to the representatives of the media for their presence at the session. Last but not the least, I would like to thank all esteemed dignitaries and members of the chamber for making it convenient to attend the conference. With these words, I request you all to join me in carrying a hearty vote of thanks to our honored guest speakers with appreciative acclamation. And now, ladies and gentlemen, time for lunch.